Kooti y'amagye Makindye enkya ya leero ezzeemu okuwulira omusango oguvunaanibwa Dr. Kizza Besigye wamu ne munne Lutale Kamulegeya nga bano bakwatibwa mu ggwanga lya Kenya gye bali bagenze gye buvuddeko. Kakati bano baggulwako emisango omuli okusangibwa n'emmundu ey'ekika kya basitoola okutaataaganya emirembe gy'eggwanga n'okulya mu nsi yaabwe olukwe. Kakati akadde kano kooti eri mu kugendera ddala mu maaso naye tukitegeddeko nti Ssaalongo Elias Lukwago agaanyi okulemberamu bannamateeka okugenda mu musango guno ng'agamba nti Karua ng'agamba nti Dr. Kizza Besigye yalonda Karua nga yalina okubeera mu musango guno. Katukutwaleko ku kooti tukulage ku bigenda mu maaso akadde kano.
We are not expecting him to raise it. But that said, Mr. Chairman, again the rule does not bar anyone, not even advocates, not even members of the public, to discuss decided cases. He talked about our continued pronouncement of the trial of civilians before the General Court Martial. There is a court decision to that effect. So it's not a matter which is sub judice, whether civilians should be tried before a General Court Martial or not. It's a decided matter. If he interested himself in the decision of Ageesigika, a copy of which Council Tugume can show him, we have a very big decision. It is there, a huge one about that. So if we are interpreting a decision of the Constitutional Court, we are not breaching any rule of sub judice. I am at liberty at any given moment, any given time, any given forum to interpret the decision of the Constitutional Court. I breach no law. What is pending before the Supreme Court is the appeal. So if I make a demand that the Chief Justice should render a decision which has been long overdue, with the commitment that was made in a ruling that I can share with you, I have a copy here, Mr. Chairman. Get me a copy. I am breaching no rule whatsoever. So if I read out, and these are things, these are matters we have said time and again on media and elsewhere. And this ruling here, Mr. Chairman, in the Attorney General versus Honorable Michael Kabaziguruka, the Right Honorable Chief Justice here and the Justices of the Supreme Court, in decision number 4, they said, owing to the matter in contention for which the appeal has now been filed, being one of great public importance, the appeal shall be accorded urgency and shall be immediately fixed for hearing, dated 5th August 2021. So, Mr. Chairman, when we stand out in the public and demand that the Chief Justice should honor the dictate of this ruling, the decision they made that this appeal should be disposed of expeditiously, we are actually asserting the rights of Ugandans in the Bill of Rights in Chapter 4. Because matters touching the Constitution, matters touching personal liberties, rights, take a precedence over any other matter. So these are the issues we have been discussing. And by now, the point I wanted to emphasize, the position of court now, which has not been set aside, and which we can freely discuss, is that this honorable court has no jurisdiction to try civilians. That is the decision of the Constitutional Court, which has not been set aside. So if I repeat it, I'm breaching no law, and no court can stop me from saying that. So that is as far as that issue is concerned. The other issue is talking about, and the last one, is about, again, matters in the public domain. Mr. Chairman, we are really shocked that the prosecutor here is talking about the defense, when indeed actually the application should be in regard to the state, the application to restrain any of the parties in this, indulging in the merits of the matter, actually that order should be directed to the state. Why? Because they have already started trying this matter in the court of public opinion. Getting audio clips which are purportedly said to be emanating from UPDF, being even transcribed verbatim in one of the dailies here and a number of other media houses. This is prejudicial to this matter. Actually, it is choreographed to condition the public out there and the international community that these accused persons here stand guilty. Contrary to the foundation of our constitution that thou shalt not be treated as a convict until proved otherwise. Now the state is already trying them in the court of public opinion. And he has not come out to condemn that and to ask any application for court to restrain them. What a shame. So Mr. Chairman, you want to conclude?
Kale byebyo nno ebigenda mu maaso awo mu kooti era nga Ssaalongeri Yasukwago ng'ayongera okukkaatiriza ekya Dr. Besigye wamu ne munne Lutale okuweebwa ebbeetu bakozese looya bo gwe baagala.